Hello YouTube, I'm back. This is my second in the series of videos dealing with character evidence and rape shield in response to Honey Badger Radio's Rantzerker 23. I mean, the Rantzerker is like 2.5 hours long. This is just a small part of it because they mentioned rape shield. So let's talk about character and rape. What rape shield is there for is it is to prevent a defendant from basically embarrassing or punishing a victim from testifying by bringing up all her bad sexual history. Right? Now, when it comes to rape, and I'm talking about ordinary rape, not statutory rape. I'm talking about non-consensual sex, right? Either by force or by like incapacity. So non-consensual type sex rape, not statutory type rape. There are only two defenses. The first defense is it didn't happen. The sex did not occur. The other defense is it was consensual. These are the only two defenses there are to rape. All rape defenses are a variation of that. So what Rape Shield says, and this this is specific Colorado Rape Shield, and Colorado Rape Shield is found in Title 18, Article 3, Section 407. 18347 is Colorado's Rape Shield. And what it says is that a witness's prior or subsequent sexual conduct is presumptively irrelevant and does not come into evidence, except what is not presumptively irrelevant are two possibilities. One, prior and subsequent sexual activity with the accused. And two, prior or subsequent sexual activity for the purpose of showing the source of pregnancy, semen, injury of somebody other than the accused. Right? So the first exception to the presumptive irrelevance, the statutory presumptive irrelevance of Rape Shield, goes towards the consent defense. The other goes towards the it did not happen defense. Now, before I get into this, I'll note that even if it's not presumptively irrelevant, doesn't necessarily mean it automatically comes in. Just because there are other rules of evidence that might prevent it from coming in. In particular, Rule 403. Rule 403 is a rule of evidence that is sort of a catch-all, too prejudicial. So it's hard to describe because it's so case-specific. But if there is a fact that would just be too inflammatory, even if it's relevant, the court can keep it out because the probative value is substantially outweighed by the danger of unfair prejudice, total waste of time, things like that, right? So you can keep it out even if it's probative if it's too unfair. But there's that too. So just because it's not covered by Rape Shield doesn't mean it's automatically in. It means that now you're back to normal evidentiary analysis. So let's talk about the two bits of Rape Shield here. So the first one, which is actually the second one listed, but I'm going to talk about it first, is to show that injury, semen, pregnancy, it came from another source. Right? So if the defendant's defense is, it wasn't me, sex did not occur, right? Because it's like, maybe she had sex, maybe she didn't, but whatever it was, I had nothing to do with it. Now, if you think about this, where this would come up with regard to trying to penetrate the Rape Shield using this, I'm not sure it comes up all that often. It might, right? But I'm not sure how it comes up, because if the defendant wasn't there, right, this would matter if the defendant was unable to establish a good alibi. So I could see it in maybe the allegation is party, booze, passed out, woke up, his dick was in me, right? So I could see that, right? Because and so if the defendant was at the party, he doesn't really he's unable to establish a good alibi, right? Because he was at the party. He might not have done it, and at least that's his claim, but he can't raise a good alibi because he was in the area, you know, and people saw him there, and he admits that he's there. So you don't raise alibi this. Source of semen, I'm not sure how you get that, because if there's semen and it's testable and the defendant really didn't do it, then the semen should the DNA should clear him. I'm not sure how. Maybe I don't know. Maybe it's not inequality to be tested, but or perhaps you got some really weird incest type situation where somebody's accusing the father, but it was really uncle, but there's not enough normal DNA, so you have to go to YSTR DNA. I don't know. If there's semen, I'm not sure how you explain away the source of semen as somebody else, but it's there. So that's what it's for. This helps if, for example, let's say a woman goes into police and says, 3 days ago, I was at this party and this guy, I was passed out. I woke up and he was anally penetrating me, and I didn't. I didn't know what to do. I took a shower. I was afraid to talk about it. I was convinced to come in and talk about it, and therefore, I'm coming in now. And they do the exam anyway, and there's some tearing around the tissue on the anus, and so now the prosecution is wanting to show that tearing is evidence that this occurred, right? And so the defense might want to bring up, it's like, well, no, because she had anal sex with her boyfriend yesterday, right, the day before the reporting, and that's where it came from. And the rape shield does not prevent the defendant from doing that. This is an exception to rape shield. So the defendant could do that. Right. So if we get to it, and we can talk about a consensual one, it really covers vindictive X type reporting. It doesn't really help the defendant if this is the first time and the defendant, say, meets the woman at the party, and then drunken sex occurs, right? And his defense is it was consent. Her story to the police is that I was passed out and he took advantage of me. I wasn't consenting. I was passed out drunk, or I said no, but he didn't listen and he just sort of forced himself on me, right? If it's the first time they've ever met and everybody agrees on that, then rape shield will protect the victim. If what the defendant wants to do is say every time she goes to a party she has sex with a different random guy consensually, therefore this time she had sex with me consensually. Rape shield will prevent him from doing that. However, if they are in a relationship and they've had sex before, and the defendant wants to bring up evidence that they had sex consensually before to show that they had sex consensually for the incident in question, the rape shield does not prevent him from doing that. Now, so much of this becomes fact-based, and where I can see this actually becoming useful is, let's say this couple is into a sort of BDSM type relationship, right? Because I mean, if they're if the accusation is he was so different, right? We were, it was a good relationship and we had sex before, but this time, he held me down and beat me up, and it's never happened like that before, and there are injuries, I mean, then the defendant's got a problem, right? But let's say they have like a 50 Shades of Grey type relationship, and what they're into is the whole, he comes in from work or something, surprises her and just sort of like holds her down and takes her, and she likes that, right? And she'll say no, but they have it before where that's part of their fantasy, right? There's going to be a safe word, and so what he wants to say is like, yeah, I did hold her down, right? But this is how our relationship has been, and she didn't use the safe word. So if that happens to be the situation, and that's the defendant wants to put forth, rape shield will not prevent him from doing that. What rape shield will prevent is showing the bad character or actually really just slutty character on the part of the alleged victim. Right. What it and really it's a date rape situation where this would matter, because if it is a drag into the bushes or drag into the alleyway rape by a stranger, I'm not sure the defendant's going to have a really good consent defense, right? If he can establish no actual acquaintance type relationship, it just doesn't happen. What I mean. The only defense this guy has is you got the wrong guy. It was somebody else, right? Victim's a racist. She pointed the first black guy, and that was me, right, or something. I mean, so this only comes up really. This consent defense only really comes up when it's at least an acquaintance, and if it's an acquaintance that where there's no prior or subsequent intimate relationship, then Rape Shield is going to prevent the defendant from saying, this woman has a pattern of going to parties, getting drunk, sleeping with some guy, right? It just happened that this time I didn't call her the next morning and she got vindictive and accused me. That particular defendant will not be able to bring in the victim's prior history of sleeping with random people she just met at a party, if that's where he wants to go with that. So that's what Rape Shield will prevent him from doing. But if you think about it, that is character evidence, right? That is to show that the victim acted in conformity with a particular character trait of, say, sluttiness. So she has a history. She's the kind of person who will randomly sleep with strangers. Therefore, she consented to sex with me, the random stranger, right? And remember, that's generally inadmissible in most circumstances. There's an exception for a criminal defendant, but what Rape Shield does is takes away that exception when it comes to rape. It doesn't take away the exception in all circumstances, though, right? If it's a date rape situation, meaning that they have been dating or they dated subsequently, that's not a shield. The defendant gets to bring it in as long as it's him to show consent. So I don't think that date rape gets rid of due process. What it does is it takes away a special exception that a defendant would get, a criminal defendant would get. It's a special exception nobody else gets to use, all right? But the defendant gets it. It takes that away in a specific type of case. I'll note that this is not the only place in the law where certain rules of evidence are accepted. For example, in a theft case, there's the hearsay rule, right? Hearsay, generally, you don't get to bring in hearsay. In theft, to prove the value of an object, sticker price works. It's technically hearsay, but you can do it, right? You don't need to bring in some sort of expert evaluator to prove value. If that's a sticker price on a stolen item, it comes in. So there are exceptions to rules of evidence that work throughout the criminal law, and so I don't think that date rape is. I don't think that the Rape Shield statute does away with due process. There are enough exceptions in it that allow a defendant to present a real defense, especially if the defense is, it wasn't me. There are plenty of exceptions that allow the defendant to bring it up. And so I think the Honey Badger is just wrong on this one. It doesn't get rid of due process. Thanks for watching. Bye.